In earlier chapters, you focused on contracts, leases, and how rights and obligations are created between buyers, sellers, landlords, and tenants. Chapter 11 shifted the lens from what does the contract say to who is this licensee actually working for? Agency law answers that question. It defines the legal relationship between principal and agent, the duties that flow from that relationship, and how those duties must be disclosed to everyone involved in a real estate transaction. In this chapter, you learned that agency is not about who pays the commission, but about who receives loyalty, advocacy, and confidentiality, and how that must be clearly documented and communicated under both national principles and Arizona's specific rules and case law. The foundation of the chapter is the agency relationship itself. An agency relationship exists when a principal, client, authorizes an agent, broker, to act on their behalf in dealings with a third party, customer. That relationship can be created by express agreement, such as a listing or buyer-broker agreement, or by implication when the parties act as if such a relationship exists. All agency relationships are fiduciary relationships, built on trust and confidence, and they can also arise through apparent authority, estoppel, or ratification when a principal's conduct leads third parties to reasonably believe an agency exists. Agency ends by performance, expiration, mutual agreement, or by operation of law through events such as death, incapacity, bankruptcy, impossibility of performance, or frustration of purpose. Once agency is created, fiduciary duties attach. You learn that the agent's core duties to the client include skill, care, and diligence, loyalty, obedience to lawful instructions, confidentiality, accounting, and full disclosure of all material facts. These duties require the agent to prioritize the client's interests over their own, stay within their field of competence, safeguard client funds and documents, and disclose anything that materially affects the client's position in the transaction, including facts the agent should have known with reasonable investigation. At the same time, the principal has duties to be available for decisions, to provide necessary information, and to compensate the agent when agreed and when the agent has performed. If either side breaches these duties, consequences may include rescission of agreements, forfeiture of commission, ADRE disciplinary action, and civil liability for damages. The chapter also clarified that agents owe duties to customers, even without a fiduciary relationship. Although the traditional buyer beware approach has weakened, customers are still not clients. However, Arizona law and commissioner's rules require licensees to deal fairly and honestly with all parties, exercise reasonable care and skill, and disclose known material defects and facts that materially and adversely affect the consideration to be paid. That means an agent cannot deceive, conceal, or silently misrepresent. They must avoid giving expert advice outside their competence and must not cross the line into negligent or intentional misrepresentation. Arizona courts, including Lombardo v. Albu and Hill v. Jones, and R4-28-1101, have been used to define the standard of care and the scope of a broker's disclosure duties to both clients and non-clients. You then explored the main forms of real estate agency: single agency, dual agency, sub-agency, and no agency transaction brokerage. In single agency, the broker represents only one party in the transaction, either as a seller's agent, listing broker, or as a buyer's or tenant's agent. Sub-agency arises when other brokers and salespersons act as agents of the listing broker on behalf of the same client, sharing fiduciary duties. Dual agency occurs when the broker, through one or more licensees, represents both buyer and seller in the same transaction. Because dual agency creates an inherent conflict of interest, it is tightly controlled. Arizona allows limited dual representation only with the informed written consent of both parties. under R4-28-1101F and expects the broker to limit advocacy and preserve confidentiality. In some jurisdictions, transaction brokerage has emerged as a no-agency model, where the broker facilitates the transaction without representing either party as a fiduciary, focusing instead on honesty, care, disclosure of material facts, and assistance with paperwork. Arizona-specific examples and forms helped translate these doctrines into day-to-day practice. You saw how the buyer-broker exclusive employment agreement establishes exclusive buyer representation, how READ, real estate agency disclosure and election, clarifies agency choices and stigmatized property issues, and how the consent to limited representation form documents dual agency. You also looked at ADRE guidance on procuring cause, the limitation on unlicensed assistance, hosting, or opening model homes, and Article 26 of the Arizona Constitution, confirming that licensed brokers and salespersons may draft instruments incidental to a real estate transaction when acting in that capacity. Throughout, the chapter emphasized that representation and entitlement to compensation are separate issues, and that procuring cause is determined by who set in motion the uninterrupted chain of events leading to a sale, not simply by who has an agency agreement. The final piece of the chapter was agency disclosure rules. You learned that modern statutes and rules require clear written disclosure of who the broker represents, what duties are owed to each party, and what options a consumer has in choosing representation. Listing brokers must disclose their fiduciary role to sellers, disclose to buyers that they represent the owner, present all offers, and reveal information such as a buyer's potential inability to perform, their own financial interests in the transaction, and all compensation relationships as required by commissioner's rules. Buyers' brokers must disclose their fiduciary role to buyers, disclose their representation to sellers and listing agents at first contact, and reveal known defects, seller performance problems, liens, compensation arrangements, and their own ownership or interest in the property. Dual agents must secure informed written consent before acting, cannot share one party's bottom line or motivations without authorization, and must balance limited duties of disclosure with the requirement to disclose material defects and adverse facts. To support all of this, the chapter closed with practical disclosure guidelines and Arizona-specific examples. You learned that if you know of a material defect, you must disclose it. If in doubt, you should disclose or at least recommend further investigation. And when information comes from others, you should identify the source, help verify it when prudent, and document everything in writing. ADRE's Substantive Policy Statement 2005.13 explains that agents cannot avoid liability by deliberately ignoring inspection reports or other obvious sources of adverse information. You also studied airport disclosure statutes, the difference between disclosing actual criminal activity in the surrounding area and non-disclosure of stigmatized property under ARS, Section 32-2156, and why an appraisal is treated as an opinion of value rather than a material fact that must be shared with the other party. Taken together, Chapter 11 teaches that understanding and correctly handling agency and disclosure is not just a paperwork exercise. It is central to protecting your clients, avoiding undisclosed dual agency, complying with ADRE rules, and building a trustworthy real estate practice.